While some ANC NEC members are at former President Jacob Zuma's Nkandla residence, many are keeping mum on the situation there. In fact, we've heard nothing from the ANC president at all. But with so little information about the party's internal affairs, where does that leave you and me? Advocate Paul Hoffman from Accountability Now. He's an Accountability Now director. He joins me from Cape Town to talk about this and various other issues. Thank you, Paul, for your time. I mean, the fact that the president of the ANC is silent, while members of the ANC are sometimes behaving in ways that perhaps do not support major issues like what's happening with COVID-19. There was no question at Nkandla. It was a super spreader event. People were disobeying the law. We saw the MKMVA in fatigues shushing off the police from doing their job in that area. What does this mean for the country when people watch this and think that, different laws, different rules apply?
Yes, I think Mr. Zuma, thank you, Omar, and thank you for the opportunity to converse with you and with your viewers. I think that Mr. Zuma is really shooting himself in the foot with the way that he is permitting this super spreader event, or what you could call a new Comrades Marathon with a route that ends at Nkandla. He's obliged, if he wants to get any relief in his rescission application, to show that the error in essence was that he was not being willful and that he was not in bad faith. That is the grounds, the essence of a finding of contempt of court. Instead of trying to do that, he's filed papers that don't really make out a case at all, and he is now conducting himself in a way that shows that he has no respect for the rule of law, no respect for the COVID regulations, no regard for the safety of his own supporters, no accountability in respect of his own willingness to entertain his supporters to this super spreader event, as you call it, and generally his irresponsibility as a leader. He cannot expect to win in court if he turns a court process into a political stunt. And that's what this latest rescission application is all about. It's a political stunt, not a court case.
All right, so if it is what you describe as a political stunt, surely the senior, smart people who have years and years of training, who are our constitutional court justices, must know that this is politically motivated. Why grant it?
They haven't granted it. All that they've done is that they've permitted Mr. Zuma, in the space of 1 week, to get his application into court. And they've done that because they respect the principle that says that the other man should be heard, and because they know that Mr. Zuma was not heard. So the question really is, why was Mr. Zuma not heard? Well, it turns out from his own papers that he was not heard because he chose not to be heard and because he followed bad advice. Now, why that should be a basis for regarding the orders of court as erroneous escapes me, and I think he's going to have a lot of difficulty persuading the court that his papers make out a proper case.
Paul, is there any danger with this particular precedent, granting the rescission application? Are we looking at potential loopholes that start to emerge in other cases where people look at what's happened here and start to use it for their benefit? Is this going to create some kind of chaos in the legal system?
Well, what we need to remember is that this is a civil contempt case. This kind of case is only brought if a litigant seeks to make an application to court for the committal for contempt of a person who has ignored a court order. And what we have is a rather unusual set of circumstances where Mr. Zuma initially tried to get, without success, tried to get Judge Zondo to recuse himself. And when that didn't succeed, he left the commission in circumstances in which his willfulness has been proven beyond a reasonable doubt in the Constitutional Court, and he has not returned since. He also did not participate in the contempt proceedings in the Constitutional Court, and now that the shoe is pinching, suddenly he wants to rely on all manner of procedural rights that he feels have been trampled, whereas in fact he is the author of his own misfortune. So remember, this isn't a case involving the Criminal Justice Administration. It isn't a case in which the police featured in any way, shape or form prior to the finalization of the majority judgment and the signing of the warrant for his arrest by the acting Chief Justice. So Mr. Zuma has a very long row to hoe if he is going to be able to persuade the Constitutional Court that it made a mistake.
Now, the basis for saying that they made a mistake is that, as you've just put it, despite the fact that he had multiple occasions to be heard, was not heard, and therefore he's got new reasons, let me call them that, new reasons for having not appeared. That's primarily what he's saying. Therefore, he is not in contempt because, hang on a second, you didn't actually hear why I didn't appear. Very sick, etc., etc. Is that really what he's going to be arguing, his lawyers will be arguing?
He's arguing illness as taking his medicine as a reason for not coming back to the commission. He's arguing illness also as a mitigating factor, militating against him being incarcerated, which is not what the law says. You know, there are hospitals in prisons and plenty of opportunity for rest and recuperation, and all of the medical treatment is free. He's really crying poverty. He's crying bad legal advice from his former legal team, and that he made some bona fide mistakes along the way. It's not going to cut it, and in fact, I anticipate that the application to set aside the orders could turn into a counter application for the period of incarceration to be extended, to be increased, because of Mr. Zuma's recalcitrant attitude, his unapologetic approach, and the whole tone of his founding affidavit, where regret and contrition just do not cross the radar in any shape or form.
It's interesting. Richard Spur, whom I spoke to a little earlier on in the program, seemed to imply that he felt that it was a very angry judgment. The majority judgment was very angry, and that's why it was such a harsh sentence in terms of number of months required to serve. And he seemed to imply that generally these sorts of contempt of court rulings might put someone into prison for 30 days or certainly a shorter period than 15 months. Is he right about that, that this was emotionally inspired judgment?
I'm afraid Richard Spur, much as I love him, is on a dual spur with that one. This is not an ordinary contempt case. This is a contempt case involving the highest court in the land and involving a former head of state who twice swore to uphold the Constitution and the rule of law when he came into office as president, both in 2009 and 5 years later. It's not a case that will arise in the ordinary course of events, and it is a case in which the applicant, the State Capture Commission, asked for 24 months straight, 2 years imprisonment, no fine, no suspensive conditions of any kind whatsoever. And the court gave a suspended sentence, a custodial sentence of 15 months, which is less than the 24 months that was asked for. And if Mr. Zuma behaves himself while in prison, he could be out in 3 months and a few days, being 1/4 of the sentence. He could be administratively released by the Correctional Services Department. So how far are we from that 30-day committal that you give to a deadbeat dad who is not paying maintenance to his kids. A totally different situation to the one that involves Mr. Zuma and his failure to comply with an order of the highest court in the land. And in fact, thumbing his nose at the highest court in the land by simply not participating in the proceedings. Now that the proceedings have gone against him, suddenly he wants to be there and be heard. And one of his complaints is that he wasn't heard. Well, it's his own fault that he wasn't heard because he chose not to go.
Yes, indeed. Paul, the issue of the police going to Nkandla to arrest the ex-president, that still stands as an order, surely. There's this hearing that's happening on Tuesday, but it's irrelevant because it's out of jurisdiction, we all know. So surely, is there any change in that? Does the South African Police Service still have an instruction to go ahead and arrest him and keep him in jail until the 12th, when the virtual hearing will happen?
I can't see any need or any indication that the permission to have the matter heard on the 12th does not imply that Mr. Zuma need not be arrested before the 12th. It's certainly urgent when a person is in contempt of court, but it's not so urgent that he needs to be put in jail for a few days pending a hearing a week from tomorrow. So if there is continuing confusion, it is open to the parties to agree, and I'm sure that the State Capture Commission will agree, that the arrest and detention of Mr. Zuma be delayed until there is finality in the rescission application. I just can't see the police being required to perform on that order.
But of course, they've already been given, this preemption here showing what happens when you do finally get told that he has to be taken to prison, whether it's now or if found guilty of any other crimes that he still has to face in court. We know what's going to happen, what we've just seen in Nkandla. What does that mean for the ANC and its leadership of society? The fact that the president of the ANC, Cyril Ramaphosa, is silent while all of this is happening, and this could repeat, depending on what the judgments are in future court cases against our ex-president.
Yeah, you're asking me a political question, but I'm just a lawyer, but I will give it a crack anyway. I think what we will see is a split in the ANC between those who do follow Mr. Zuma and the radical economic transformation faction of the ANC, and those who still believe in the rule of law and the supremacy of the Constitution. And that split will make South African politics a healthier place than it is at the moment.
Thank you very much for your time. Advocate Paul Hoffman, Director of Accountability Now.